Hey everyone, Mike Harris, Goals Director of Public Policy, back again for another legislative update. We're doing the series weekly to fill you in on what's going on up at the Massachusetts State House and to outline a bill you should probably know about. I'll also tell you how to get in touch with your legislator and what you can do to get involved yourself. All right. So to begin, the comment period for the ATF's rule change regarding the reclassification of pistol braces is over. There were 211,564 comments in all, according to the federal government's regulations.gov page. And as with the comments regarding the ATF's definition of a firearm, there's no way to tell how many of those comments were in favor of or against that rule change. And we will see how that shakes out soon, I am sure. But meanwhile, back in Massachusetts, as always, the State House is still closed to the public. And we still do not know when it might be reopened for visitors. However, it is now mid-September. The legislature is back at it, holding hearings, voting on bills, and handling constituent cases. So they're back there. Legislative committees are still holding virtual hearings over Zoom, requiring anybody who wants to testify to sign up in advance. Each speaker who would like to testify is given 3 minutes to speak in total, regardless of how many hearing items they would like to discuss. There's a hearing schedule on the Massachusetts or the MALegislature.org website that breaks down the date of each hearing with the list of bills to be heard at each, and we can put that link in the description below. There doesn't seem to be any hearings regarding any firearms-related bills coming up within the next week. But Goal is constantly keeping an eye on the schedule, and we will certainly alert you when anything of interest comes up. We're always watching that one. In related Goal news, this Sunday, September 19th, Goal will be holding its first advocacy workshop for those who would like to get involved in Second Amendment advocacy. It's going to be held at Mansfield Fish and Game, and we will be covering topics including the Massachusetts legislative process as a whole, hearing procedure, how to read a bill, drafting testimony, testifying before committees, how to effectively communicate with legislators, how to get your message out in general, and how to use the Massachusetts Legislature website. It's a huge resource. Fortunately, sign-up is closed for this seminar, but response has been great, and we will be planning to do more of these in the future, we hope. Thank you to everyone who signed up. And I'm excited to see you there. Hopefully we can do some more of these in the future, like I said. However, right now in the Commonwealth of Massachusetts, if an extreme risk protection order or an ERPO or red flag order is issued against a person and a judge deems them a risk to themselves or others as defined by Mass General Law, Chapter 40, Section 131R, that person is directed under Section 131S to surrender their LTC or FID. Additionally, any and all firearms, rifles, shotguns, machine guns, stun guns, and or ammunition they possess, control, or own must be surrendered temporarily to the licensing authority where they reside, aka the police department. Once in the licensing authority's possession, the owner will be given a receipt listing the items, and the items will often be transferred somewhere other than the police department premises. It could be a bonded warehouse, a gunsmith, firearms dealer, or other location suitable for the storage of guns and ammunition. Upon termination of an ERPO, if the licensing authority reinstates the subject's LTC or FID, it could be a rather fraught process. The law currently makes no real mention of who's responsible for the payment of storage fees for confiscated weapons. The licensing authority sends them to a bonded warehouse or other private location that charges a fee for storage. Obviously, this is problematic as the subject of the ERPO could be denied the return of his legally owned property, their own property. This is when House Bill 2453, an act relative to the lawful return of property, would be useful. The bill would ensure that the owner of any guns temporarily transferred to a private business for storage without the expressed written consent of the owner would not be charged any fees as a requirement for the return of those guns. This is a much-needed protection for gun owners against an end-run denial of their Second Amendment rights. They deserve to get their stuff back if they didn't voluntarily give them up. The bill was filed by Representative Sean Dooley and referred to the Joint Committee on Public Safety and Homeland Security, where it is currently awaiting a hearing. Goal assisted Rep. Dooley in drafting the bill, so we're definitely in favor of its passage, and we will let you know if and when it is scheduled to be heard, and we'll put a link in the description of the text of the bill below. And that is it for this week's Goal Legislative Update. I'll put a link to Goal's interactive legislator map in the description below, like always. And please help us advocate for your rights by advocating for yourselves. Contact your legislators and let them know how you feel about the bills coming across their desk, be them firearms related or not. And thank you so much for watching. We will see you next week.